These are the scales of a democratic country. We proposed, because the Constitution implementation demands that we propose legislation that will guide media in our country. And in accordance with the Constitution, it must be free of commercial, political, or any other interests. That is the law that we proposed. There has been consultations between the media players, National Assembly, and the executive. And I think they have been robust. In fact, the memorandum that was sent to Parliament by the President was informed by those considerations. I remember very well the CIC met with the executive, met with the National Assembly, met with the media owners and the Media Council, and they made certain suggestions on the basis of which the President returned the bill to Parliament with a memorandum. We were surprised that that was taken to look like it was worse than the original fashion. Bear in mind that the tribunal that was proposed was actually proposed by the Media Council, right? And all that has been done is to make the tribunal more representative, bringing in users of media and other players, so that we can have a mechanism that does not have the media alone, but has all other players in there. If there are any sections that are unconstitutional and the media or media practitioners go to court, I am sure the court will take out those sections of the law that are unconstitutional, because that is how the system has been made to work, that there is a comprehensive, elaborate system of checks and balances that will ensure that no legislation that is against the Constitution that was passed by Kenyans survives or sees the light of day. So I don't see any threat to media in our country, because there are sufficient checks and balances. The executive cannot exceed its bounds. The legislature cannot exceed its bounds. The courts have their own role to play. So if there are any issues, I do not see why there is a huge alarm in the country on protection of media.